What's going on, everybody? How y'all doing? Welcome, welcome, welcome. Come on in, come on in. Hit the like button, hit the like button. We're gonna get started. I wanted to do this quick live, right quick. We have a couple videos to watch and some information I need to share. One of our fantastic mods here doing some research on some potential information coming my way. I always get information that it just comes out of left field, and it's like, where y'all getting this stuff from? So shout out to Francisco. We got some fantastic mods in the LLC that are always ensuring the information here from the Lady Luck Club is accurate. And then of course, I'm always gonna vet and double check information. I got an email about a video link that didn't even go to what they put in the actual email itself. And I'm like, oh, where y'all get this from? I'm not gonna just show it because I was sent this. I have to vet it. And if it doesn't even match what you sent me, then no. So we got to vet our stuff up in here. We've already been burnt in the past from malware. There's one thing she reminded me of. Don't just put out information just because someone emailed it to you. You gotta vet it, double check it. And so that's what we're gonna do here. And I'm gonna read some stuff before I get into the videos that we have lined up from Attorney Dennis Spurling. This is some information on victim protection versus defendant exposure in the Texas case of, of course, between Carmelo Anthony and Austin Metcalf. And then I'm going to pull up some information on the appellate process. So you guys can see what that's like. And when they send their file an appeal, you can know exactly, what's happening. This is the 5th district, I do believe, 5th circuit. So the more you know. Let me make sure I got the right one. All right. Oh man. Woo. Okay, so let me do this. I'll just go over what it is. All right. Yeah, we'll just go over the overall appellate process. It's like 200 pages of appellate procedures and guidelines from 5th Circuit. Oh, good grief. So, before we get to the videos, let's shout out to everybody up in here. Mackenzie and Heather are members again, renewing their memberships. Don't stop. How you doing? Mindy's back with us. Shout out to the moms, you all. Jeep Lady, how you doing? Hey, I'm back. I had to put kids to bed. Don't worry, I'm right behind them. Yeah, shout out to X-Files. We got the kangaroo court. Oh, because it was a kangaroo jury. I mean, kangaroo court. You heard of that? Yeah, no, I heard kangaroo court, and that's not it. Oh man, that dude was so mad. Oh Lord have mercy. What's going on? How you doing? How you doing? Everybody speak to everybody. X-Files up in here. Shout out to you, honey. Hope all is well. Thank y'all so much. Let's go. Let's get to it. So I'm gonna read this information first. It says, and this is from shout out to Francisca. Wanted to share some clear information about the rumors starting to circulate about this Austin Metcalf and Carmelo Anthony case. There's a lot of confusion online, especially from TikTok and commentary channels, i.e., Metcalf mother saying her sons were not angels, cheerleader talking about Hunter's anger issues, Metcalf father intimidating witnesses in court and throwing watermelon signs, etc. In U.S. law, especially in Texas, victims, particularly minors, are legally protected from having their school records, behavior history, or personal background exposed in court. This is to prevent victim blaming and to protect their privacy. Naturally, we have federal laws that protect student records. So what you see with HIPAA privacy protecting medical records of patient information, we have federal laws that do the same for school records, for especially for minors. All right. The defendant does not have the same protection. The prosecution is allowed to use the defendant's school records, suspensions, behavioral issues, and past conduct to establish a pattern. This is why Carmelo's school history was discussed publicly, but the Metcalf twins was not. Victim character evidence is generally banned unless it directly relates to the incident itself. General behavior like bullying, rudeness, or anger issues is not admissible. This is standard US procedure and not a sign of bias. Because, people don't read laws. So understanding what would be permissible evidence in court, such as edited videos, are not permissible evidence. You cannot admit edited videos as evidence into any case, civil or criminal. Doesn't matter. Because if that be the case, then everybody would be doing it. And it doesn't make it credible. So there is court rules on how to admit evidence into a case dealing with digital documentation, such as photos and video or audio. Sometimes people just have an audio file. There are court rules on how that should be admitted. Emotional behavior from the victim's family in the courtroom, including crying, gestures, or reacting strongly, is usually allowed in U.S. courts unless it disrupts proceedings. It does not count as judicial bias. American courtrooms are far more emotional than like UK ones. The judge's role is to ensure the legal process is followed. Allowing emotional reactions is normal in the U.S. justice system. It does not mean the judge was favoring one side. Because if that be the case, no one will be able to sit and spectate in court. Because then they'll look at a facial expression or you raising your eyebrows around or something like that. Then they kick you out because you shot this look. It's like, typically, even clapping is a form of First Amendment freedom of expression. But it cannot be disruptive, especially in the courtroom. That's the last place you want to disrupt anything. You want that proceeding to move forward. The key legal issue remains that bringing a knife to a school event is treated as intent under Texas law. Yep. And we went over the Texas Penal Code as well in a previous live. This point alone carries significant weight in the verdict and is difficult to overturn on appeal. And not just him bringing the knife, he pulled it out with the intent to use it. And then provoked by saying, touch me, see what happens, punch me, see what happens. You're not going to take time to pull out a knife out of your backpack if you had no intention on using it. So that's just some researched information from our fantastic mod, Francisca, here in the LLC. All right, y'all. Let's get to oh, hold on. We'll go ahead and pull up. I got two videos that I wanted to show. The first one, of course, is Dennis Spurling. I would love to have him from the Spurling Report. I would love to have him in the LLC. He is a bar licensed attorney. I think it's weird, like people thinking they gotta agree with him or something. Like, you don't have to agree with him.
I can lie to you.
He's an attorney, though. If anybody has any insight on how this is gonna go, it's gonna be an attorney, especially an attorney that deals with criminal defense. So, shout out to all of you all coming in. Hit that like button. Hit that like button. Don't be shy. Thank S Files, Juju. Hit that like button. Hype the videos up. Hey, Patrina, how you doing, honey? How's it going? Y'all, tomorrow we're going to have Ryan Morrow here in the LLC, and he has been adamant in his research and diligent in his research and foreign influence and interruptions they've had over here in the U.S. Thank y'all so much for tuning in. Sherry, how you doing, girl? So we got Dennis Spurling in the house. I'm just going to do this in real time. I'm going to leave a comment and ask him, how do I get in touch with you? I would love to have you in the Lady Luck Club. Yeah, I am rapidly becoming a huge fan. We've had attorneys here in the Lady Luck Club. Nick Brooks. Would love to have Dennis Spurling come over and talk with us. This is how I learn. And I learned by listening to the experts, and I consider, those who went to law school, practice law, especially criminal defense law. Those are the experts to me. And that's where we go to get the facts and to have a better understanding of the process and the procedure and even interpretation of law. Attorneys are considered officers of the court, and they would know more than somebody on YouTube, to include myself. So that's why we go to the experts to get our information. Whether you agree with him or not is irrelevant. As long as he's factual and he's able to give his own opinion, he's able to kind of formulate his opinion on where he thinks this is going to go based on the knowledge he has regarding the appellate process and the evidence related to the case. What are the chances? What are the odds of Karmelo Anthony getting, an appeal granted to where he can get a new hearing or a new trial? So I wanted to check out his thoughts on this. Shout out to Dennis Spurling. Hopefully he'll reach out to me and we can have him over here in the LLC to be able to chat more. And plus, his insight on ensuring that we're teaching our kids to de-escalate and not to be hotheads. Every situation does not call for a full-blown battle. Sometimes you just need to walk the hell away, especially if it means you avoiding doing something that can have severe repercussions. Just walk away. So let's get to this. Y'all hit the 4 when you can see in here. Let's go.
Make you feel good. You want me to feel good, I'll make you feel good. It won't be the truth. And you'll be very disappointed when the truth comes out. At least now you can get prepared.
Hey,
Tammy. That's one of the issues. Batson is another one. Right? Self-defense.
I think he's looking at his live chat.
I mean, what are you gonna do? Again, as I say, Batson, you got to show that
What are you looking at?
You got to show that it's not just enough to say, not just enough to say we had all a white jury or they struck all the black jurors. They have to.
And here's the thing. These 6 attorneys now that are taking over this appeal will look at the jury selection process to determine whether or not there were any errors that occurred or any violation of law or court rule that dictate how jury selection should flow, especially for a criminal proceeding. So if there are any errors with that selection process, that will be in the appeal. Their job is to find legal errors, oversight, misinterpretation of law, oversight of evidence that would be material. Whether motions, had the preliminary hearings address motions or filings that should have been, addressed with the court prior to the murder trial. So if you have a motion in limine to exclude information and the court never even heard that motion in a hearing, and let's say there's a chance the motion would have been granted, now you have information or evidence that was included that could have been excluded that may change the outcome, meaning it has some sort of material or significant impact. That's what they're looking for. Not just going in and saying, "Oh, we heard it was all white." No, they're gonna find out factually if it was an all white jury, to which um it was proven that it was not an all white jury. There was some non-white jurors on the jury. Then the question would be, brought into play as to what happened with any possibility for black jurors. If the black jurors recused themselves or somehow were recused because of some level of bias, and the law supports that and permits that's going to be rejected in the appellate court. But that's what the attorneys are doing. They're looking for any issues like that would have significant impact or be material to the case. Does that make sense? Hit the floor. So even for me, I'm like, it's my opinion that I feel that more than likely there will be a denial, but you never know. I've said that this whole time. You never know. Sometimes things might take people off guard. You might be surprised. They might find a couple legal errors. Who knows? I have to read the appellate pleading, the appellate documents they present to see exactly what the issues were. But I always leave it wide open to say, who knows? Sometimes you might be shocked. So let that happen. Let them address the issues. Let's get the appellate documents in. We will read it here in the Lady Luck Club. And then do a breakdown on what they found, if anything, regarding legal errors. And if it was something to do with jury selection process, it will be in that appeal. That's like one of the main things that you find typically as some sort of legal error justifying, a new trial, is the jury selection. Or if there was intimidation of jurors, or if the jurors had any level of misconduct or any, conflict of interest with jurors. Those are like standard typical issues you come across that could warrant a new trial when it comes to the jury itself. But let that happen. Let the attorneys figure that out and let them go through it and see what occurred.
Deal with the states, race, neutral. Explanation, shout out to 99 Problems.
It's bars.
They have to show those explanations were fake. And on appeal, the trial judge gets deference. In other words, we're going to believe him unless you show us why we shouldn't. Absolute evidence to show us why we shouldn't.
Yeah.
So again, Batson is the best argument. And it sounds powerful to the public, but it's a record-heavy, fact-specific fight.
Yeah.
That evidence might not be in there. Then there's this jury charge issue. There's this jury charge issue. People keep bringing that up. I don't even know if that's true. Have y'all seen the jury charges?
I haven't seen anything about that. Anybody see
but
it?
The appellate court will have.
Listen, where's the evidence on this stuff? Because that's what you need. You can't take theories to the appellate court. And these attorneys are not going to risk their careers or bar licenses to take theories to the appellate court. So where's the evidence on jury charges? Which juror was charged? What's going on, Grave Seeker? How you doing? The bars, how you doing, honey? Shout out to the bars. Tammy, did I say something to you, honey? Anyone heard that? Like, these theories are not going to work with judges. So far, what they do is this. Because we have a checks and balance in our judicial system. So the appellate court is what he just said. They're going to uphold the ruling of the lower court until you prove with the finding of fact, law, and evidence as to why that ruling should be overturned. Until that happens, this trial judge, meaning the judge that handled the murder trial, ruling will be upheld, which came from the jury. So that's going to be upheld until there is sufficient evidence with the law supporting any legal errors that occurred that should lead to a conviction being the conviction being overturned. It's that simple.
Actually, look at the written jury charges. Did somebody mistake the law? I don't think that's probably going to be hard to prove. Pretty easy. All they get the same template they've been using for years.
Yep.
Did it improperly limit self-defense? Did it confuse the jury? Did it shift the burden? Did the defense object? If the charge was legally correct, this issue goes nowhere fast. If the charge was wrong, but nobody objected, the standard gets much harder. A jury charge is just a piece of paper. It's like 20 pieces of paper with all the law, and the judge reads it into the record. He typically goes over it and over again, him and the law clerks. They'll give a copy to defense counsel and the prosecutors. And they'll look at it and make sure it's accurate. I don't know. Improper witness opinion testimony. I understand that they ask all these lay witnesses whether or not they thought it was self-defense or not. So they might say, well, that's improper witness opinion. That they're not allowed to give expert testimony. And whether something is self-defense or not is a legal decision. But again, preservation matters. Did the defense object each and every time? Did the judge rule? Did the test?
Okay, when he says jury charge, is he talking about a juror being charged or the jury charge? Like the jury instructions? Because a jury charge is the set of legal instructions a judge gives to jurors explaining the law and guiding them on how to apply it to the facts of the case. Definition and purpose: a jury charge, also called jury instructions, is delivered by a judge after all evidence has been presented and closing arguments are complete. Its primary purpose is to explain the relevant law, define the standard of proof, and instruct jurors on how to apply legal rules to the facts they have heard during the trial. You know why? Because you're being tried by a jury of your peers. On average, a 12-person juror, the majority of them will not have been to law school and probably has no idea what federal rules of criminal procedures are or canons or anything. So you're trying to explain to the layman person, an average, regular, registered voting citizen, how to apply and interpret law to be able to deliberate and give a verdict on something that could affect someone's liberty and freedom. You really think they just hear all this stuff and then they go back there with no instructions on anything, and then they just come out with a unanimous vote? That's not how that works. You're entrusting someone's liberty and freedom in the hands of 12 people. Out of 12, guaranteed 10 of them on average did not go to law school. So the jury charge or the jury instructions is what the judge will give them to help them understand, based on the facts and the evidence of the case, now here's how you apply it to the law and to court rules. Jurors are not expected to know the law. Here you go, because if they're not expected to know the law, then you have to understand that many of them did not go to law school, so they will not know how to interpret the law. You have people that believe case law is just, it's like somebody's opinion. No, case law is law, just like a court order. A court order is held as a standard of law, and you violate that court order, it's no different than breaking the law. That's why people get held in contempt and go to jail sometimes, or at the very least get fined or sanctioned. But I mean, basic things like that, the average person doesn't know that. And since they're not expected to know the law, the charge ensures they evaluate evidence within a legal framework rather than relying on personal opinions or assumptions, because no one should be doing that. Your jury should be neutral and impartial. Having your so-called personal opinions and assumptions invoke bias. And if you want to talk about reasonable doubt, if people just don't want to agree on something based on their opinion or assumption, they will never get anywhere. Jurors would not have any purpose at all if it becomes a matter where everyone's serving on the jury is basing everything based on how they feel about it. Facts don't care about your feelings. This protects the fairness of the trial and the rights of all parties involved. So if you have people walking around here talking about, oh, the judge gave them a jury charge. Do you know what that is? Why are you sitting here saying this? Because it came off when I first heard this, like he's saying, or like someone was saying this implying that a juror was charged with something. But the juror charge itself is just some instructions. So that's standard. That happens in every case, like especially in criminal matters. What are you expecting? What is any case where it involves a jury? You can have a jury demand for a civil proceeding. Why are people not like just look this stuff up? As a matter of fact, let me drop a link in the chat. This information is being cited and drafted from legalclarity.org, a reputable, great website for resource and information. That way, reading is fundamental. This is a matter of just people doing a quick Google search. Like, it is so crazy. So the way it's being explained is that it has nothing to do with someone being charged on the jury, like having committed a crime. They're saying jury charge as in the jury instructions. That is standard. When you have a jury demand in a trial where a jury has come out and give a ruling on anything, you have a jury charge. That is standard. That is not appellate worthy. It'd be different if and what he's saying is the prosecutor nor the defense attorneys objected to the jury charge itself. They did not object to the jury instructions given to the jury by the judge. So what would there be to appeal if neither party objected? They didn't object seeing the jury charge, reading it, and saying, Your Honor, actually what you cited here is incorrect. This violates a court rule. Does that make sense? Hit the 4. Both parties' attorneys are going to read it. They're going to read the jury instructions, aka jury charge, and then they themselves have to actually go through it, determine this to be correct and accurate. If there are any inconsistencies or inaccuracies, that is the moment for either the defense attorney or the prosecutors to object. And then they need to state what the legal objection is. And if there are issues with the jury instructions, they have to point it out during the trial. And what happens is it should be corrected. And then the jury is given an amended or new set of jury instructions. And they have to then use that to go back and deliberate, come out with a rule. He's saying neither party objected. So what are we talking about? That's not an issue. That is that's normal. Once again, people who didn't go to law school sitting here picking out issues that they don't understand. Man, you can't make this shit up. Oh my God. You got the key components of it is the explanation of law, the burden of proof. It is the prosecutor's job to prove beyond a reasonable doubt. In civil cases, it explains the standard of proof applicable to the claims. Evaluation of evidence, deliberation guidelines. The charge provides rules for jury deliberations, including the need for unanimity, like a unanimous ruling in criminal cases on how to handle questions and deadlocks. Yeah, I mean, here is the information right here. Flawed instructions can lead to a mistrial or an overturned verdict on appeal. regardless of the strength of the evidence. It ensures that jurors apply the law consistently and fairly, protecting both the defendant and the plaintiff or prosecution. In criminal trials, it safeguards constitutional rights under the Sixth Amendment, while in civil trials, it supports the Seventh Amendment right to a jury trial. So if there was something wrong with the jury instructions from the judge, you do not wait until a ruling has been given and a sentencing hearing has been done. If the attorneys took the time to read it during the trial hearing, and they have the time to do that while the jury is out deliberating, that is the moment the judge will ensure both parties have a copy of the jury instructions, and that would be the time for them to try to, render objection and to have the issues corrected. But if they didn't even provide any objection, then saying after the fact that it's flawed is ridiculous. And who is saying that it's flawed? Because I can guarantee you it's not someone that went to law school. You can't make this stuff up. You have people's opinions that probably going to make the appellate process even harder for Karmelo. Karmelo Anthony's fans are going to make it harder for him to appeal because of all these dumbass conspiracy theories.
Then there's this jury charge issue. People keep bringing that up. I don't even know if that's true. Have y'all seen the jury charges?
Exactly.
But the appellate court will actually look at the written jury charges. Did somebody mistake the law? I don't think that's probably going to be hard to prove. Pretty easy. All they get the same template they've been using for years.
Exactly.
Did it improperly limit self-defense? Did it confuse the jury? Did it shift the burden? Did the defense object? If the charge was legally correct, this issue goes nowhere fast. If the charge was wrong, but nobody objected, the standard gets much harder. A jury charge is just a piece of paper. It's like 20 pieces of paper with all the law, and the judge reads it into the record. He typically goes over it and over again, him and the law clerks. They'll give a copy to defense counsel and the prosecutors. And they'll look at it and make sure it's accurate.
Yep.
I don't know.
They didn't object.
Improper witness opinion testimony. I understand that they asked all these lay witnesses whether or not they thought it was self-defense or not. So they might say, well, that's improper witness opinion, that they're not allowed to give expert testimony. And whether something is self-defense or not is a legal decision. But again, preservation matters. Did the defense object each and every time? Did the judge rule? Did the testimony actually affect the verdict? Shout out to Big J. Again, if all that happens, then it becomes much weaker.
If the attorneys tried to say that these 20 witnesses could not possibly speak to whether or not they believe that he was acting in self-defense or not, they would then have to show how they can get someone in as an expert who did not witness the event at hand at all, or be able to see it in the video clearly enough to be able to give some expertise on whether or not they feel or believe, based on the evidence, the video evidence more than likely reflects that he acted in self-defense. The best witnesses for that situation would be those who were there in person. I mean, it comes down to, the intent. If he pulled out a knife out of his backpack and then says, touch me, see what happens, punch me, see what happens, you can't be devoid of logic. The average person would not say those words if you are in fear of your life and you feel that you're going to have to act in self defense. Saying to someone, provocation, saying to someone, touch me, see what happens, punch me, see what happens, is a clear sign you're inviting the actual physical contact. But people who are in fear of their life do not do that. The reasonable viewer, reader, listener would not invite any physical altercation from people that they are in fear of their life of. You're supposed to be scared of these kids and you're inviting them to touch you and punch you. And the moment he pulled that knife out, he had the advantage because no one else had a weapon. Or else he would have said that. Carmelo Anthony himself would have said, two of them had a knife. I didn't have a choice. I had to pull out my knife because they had knives. That would have already been established. So you got a knife against some fists. And we didn't even see fists throwing in the video. 98% of the time he was sitting under the tent. They were all sitting down. You cannot physically be involved in a fight sitting down where you're not near him and you don't see anyone punching or throwing blows or waving arms. You don't see any of that motion you expect to see in a fight. So an expert witness who was not there, their so-called ability to say that he acted in self-defense would still come into question. Because now you have to question the validity of an expert witness relying on him to basically watch a video to make that determination. Would that be sufficient? And why should his testimony, and he was not a witness there in person, have more credibility than the 20 witnesses that actually were there in person? That make it make sense. You end up at the same place. All because a bunch of people throwing out conspiracy theories that did not go to law school. They're not thinking about this legally speaking. The video evidence simply corroborates what the witnesses saw. And even if you take away the question of whether or not he acted in self-defense, did you see him stab Austin Metcalf in the chest? Do you believe that there were any other options for him to defend himself other than using a knife? Since you don't want someone to ask these kids that were there in person and saw this happen, whether they believe that he acted in self-defense. Because it could just come down to wording. So if they rephrase the question and still get the same answer, then what? This is why I would love to have Dennis Spurling on the show. So we can ask questions like this. For a whole ass attorney that went to law school.
On appeal. Judicial coercion. That's another issue people keep raising up. If the judge pressured the jury to hurry up. Because remember, this trial lasted 4 days. That was quick. I think they deliberated for about 4 hours. And there's some rumor that the judge told them, well, yeah, if y'all don't hurry up and come up with this ruling, you're going to stay in the hotel tonight. And in that regard, did the judge pressure the jury to hurry up? That could matter, but the exact words matter. A judge can talk about scheduling. A judge can discuss logistics. A judge can tell jurors what happens next. And that's called sequestering, by the way. A judge can tell jurors what happens next. A judge can't do it. He can't pressure them to hurry up and reach a verdict. Not like that. Nope. So unless the record shows real coercion, not just discomfort or inconvenience, this issue is not going to go far either.
Oh
and what about prosecutorial misconduct? I don't know. That's what you're saying. They may not.
Was there any malicious prosecution? Most people who did not go to law school would not understand that concept. Prosecutorial misconduct of any sort still comes down to misconduct of an attorney. I mean, the same question can be asked about the defense attorney. Like, this is crazy. And he's going through all the scenarios of or questions that you typically see in an appeal. And the chances of all of these options he's giving out having some level of conviction being overturned. So he's given the probability of, what's the chance of this particular issue leading to the appeal being granted.
I mean, people may not like the prosecutor's tone.
Was it?
They may not like arguments. They may think the state was unfair, but that doesn't automatically equal reversal for misconduct or reversible misconduct. The defense actually has to object, ask for an instruction, and sometimes move for mistrial. If they didn't, the issue gets waived more likely than not. And even if there was misconduct, the appellate court still asks whether that even would affect the trial. Because you got a dead body, a murder weapon, dozens of eyewitnesses, and a confession. So did that really affect the trial? Did that affect the evidence? That's what they're saying. Ineffective assistance of counsel, I talked about that. It may be an issue people yell about most. I heard y'all on the internet.
Yeah.
You don't win ineffective assistance of counsel by saying the lawyer looked bad on the internet. You have to prove deficient performance and prejudice. You have to show the lawyer's work fell below constitutional standards, and the outcome probably would have been different. That's a brutal standard.
Exactly. No, Your Honor. It was in improper counsel because he lost. How dare he not represent Karmelo Anthony? That's improper conduct of the attorney. I mean, honestly, think about it. If the parents raised well over $600,000, they only paid $75,000 for their son's legal defense, when the money is for the legal defense and nothing else. If they wanted to elicit help because they were doxxed and they had to relocate, that could have been a separate, fundraising. I mean, honestly, they should have separated the funds, because what they end up doing is using some of the funds to help them live, when the funds for the legal defense should have gone to the legal defense. They had more than $75,000 to pay for legal defense, but they went cheap, and it wasn't because he was white. They just went cheap. If it would have been a black cheap attorney, it would be the same thing. Oh, now the attorneys are cool, Lady Luck. He didn't represent black people. He was incompetent. No, he lost. And attorneys understand you win some, you lose some. That's it. Now, one thing I can't say I disagree with Dennis on is whether or not having a black attorney would have mattered at all when it came to the ruling itself. So, Karmelo Anthony hiring a black attorney? Irrelevant. Skin color should not have any place in our judicial system when it comes to being neutral and impartial and sticking to the finding of fact, law, and evidence in any proceeding, in any case, civil or criminal. So whether the attorney was black or white, it still comes down to the law and to the evidence and the facts. His race would be insignificant if the attorney they hired for $75,000 was black. Same outcome, and probably would have been able to say flat out, like, "Look, man, I'm gonna try at least first try to get a plea deal. We don't have to accept it, but let's see what they're offering. And y'all need to get rid of this fake ass minister of justice. Go get his ass on somewhere. He did nothing. Maybe this attorney didn't feel like he had, the gumption, or it wasn't his place to tell the parents, this is not a good look what this minister of justice got. Because I'm still curious as to how much they paid him He called the parents of Carmelo Anthony. No one invited him out there to do any of that nonsense. He called them. He had to get some money out of this. Otherwise, he wouldn't have wasted his time. You don't see him handling black on black crime. So they got what they paid for. Like, I don't think it would have mattered whether they spent 75 or 175,000. They should have utilized the expenses for what it was for, but the outcome would have been the same. Maybe with some attempt to get a plea deal, just to see what they're working with. It's that simple. So race should be insignificant, as our Constitution says it should be when it comes to matter, that goes on in the court of law.
Brutal standard. And because the trial record usually doesn't explain why lawyers made certain decisions, ineffective assistance of counsel often fits better in a habeas corpus non-direct appeal. Look, even the punishment is also hard. 35 years sounds like a lot, but murder carries a wide punishment range in Texas. Mm-hmm. So the sentence itself is not automatically illegal or reversible. Right. The better punishment argument would have to be about improper evidence, bad punishment instructions, or lack of mitigation or ineffective assistance. Again, it depends on the record. So the big picture is this. None of these issues are easy. Not one of them. Okay? None of them. Not one.
Yeah. I think the chance of him winning an appeal is...
It's going to be hard. It's going to be very hard.
5%.
I'm not saying the appeal is impossible, but this is going to be very hard. And the appellate lawyers may find something real in the transcript. Maybe the Batson record is stronger than we know. Maybe the jury charge has a real defect. Maybe the judge said something improper to the jury. Maybe the trial counsel failed to preserve some obvious errors. Maybe there are habeas issues later. But right now, nobody should be selling people false hope, and I refuse to do it.
Right.
I'm not going to do it.
Exactly.
I'm not going to lie to you to make you feel better. Or try to keep y'all from calling me names. I'm going to tell you the truth over here.
Period.
It's all I do. I take pleasure in it.
Point blank.
I'm not here to sell you false hope.
Thank God.
Appeals are not won by outrage. Appeals are not won by vibes.
Exactly.
Appeals are not won because people think the trial was ugly or unfair. Woo! Appeals are won by preserved legal error and that cause harm. That's the problem with this appeal.
Yep.
A lot of issues sound strong when people talk about them online. But once you put them in...
When you go to court, though, it has no merit. Because you have wannabe YouTube attorneys that went to FDMG School of Circus Clowns trying to litigate something on YouTube. When you go to court, notice how this stuff becomes irrelevant. It's the same thing with that Minister of Justice. He came out swinging out the gate with this race baiting narrative. And yet, when he was charged with shaking a 2-year-old baby to the point where the baby had brain damage, he didn't go to court talking about everything so racist. Your Honor, this is all racist. I was defending myself. The 2-year-old baby spat up on me. Baby's mom was trying to leave me. He didn't go to court talking about something being racist. That Minister of Justice, fake ass Dominic, whoever his name is, he took a plea deal. He pled guilty. He was convicted. He didn't go in there talking about racism and all this other stuff, and it still walk around here trying to put us on a tree. Like, he didn't say any of that in court. When he had to stand before a judge, none of that came up. How convenient. Because he knows that shit does not work in court. He does know that. You don't have to be an attorney to know that if you've had one appearance before a judge at any point in your life, going in talking about racism and blah, 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 just to get away with doing something to a 2-year-old baby, will do nothing but piss that judge off even more. So no one is gonna ask why this fake ass minister of justice went to his court hearing talking about racism and stuff. Ask him why you didn't go to your court hearing crying racism. Come on now.
Inside an appellate standard review, they get weak. And once you ask whether the issue was preserved, they get weaker. And once you ask whether the trial judge gets deference, they get weaker than that. And once you ask whether the error actually changed the outcome, they just disappear. Again, you got a dead body, a murder weapon, dozens of eyewitnesses, and a confession. That's the reality.
Yep.
So yes, Karmelo Anthony has an appeal, but every issue has a wall in front of it, a big one. Legal sufficiency was the jury rational based on the evidence? Batson has a pretext and deference problem. Jury charge error has a preservation problem. Witness opinion testimony has an objection problem. Judicial coercion has the exact wording problem. And prosecutorial misconduct has a preservation problem. Ineffective assistance of counsel has that Strickland problem. You got to be, he was drunk and sleep.
Yeah.
And still no ineffective assistance of counsel. And that's why I keep saying the same thing. Look, man, I'm not going to lie to you. This appeal lives and dies on the record. And the record is ugly. If the record was strong, he had a fight. If the record is weak, all this internet outrage in the world is not going to save this boy from doing
exactly, because none of this internet outrage from these fake wannabe YouTube attorneys are able to get Karmelo Anthony out of prison. It's not going to get him released out of prison. You have people race baiting and weaponizing this case as if it makes a difference with him getting out of prison. He's still there. It didn't work when they found him guilty and when he was sentenced. Why do people believe it's going to work now? When you would not be able to make any of these legal arguments, he literally just put out there like it just rolled off his tongue. These same people screaming and hollering how life isn't fair cannot make any legal arguments on any of these points that this whole ass attorney just brought up.
So yes, Karmelo Anthony has an appeal, but every issue has a wall in front of it, a big one. Legal sufficiency was the jury rational based on the evidence? Batson has a pretext and deference problem. Jury charge error has a preservation problem.
3.
Witness opinion testimony has an objection problem. Judicial coercion has the exact wording problem. And prosecutorial misconduct has a preservation problem. Ineffective assistance of counsel has that Strickland problem. You got to be, he was drunk and sleep. And still no ineffective assistance of counsel. And that's why I keep saying the same thing. Look, man, I'm not going to lie to you. This appeal lives and dies on the record. And the record is ugly. If the record was strong, he had a fight. If the record is weak, all this internet outrage in the world is not going to save this boy from doing his time.
Nope.
So when it comes to the case of Sammy Lee.
Shout out to attorney Dennis Spurling. Oh, that was good. 8 good points he provided. And, he's like, listen, this is the chances of it all. Karmelo Anthony has the right to an appeal. Is the appeal viable? Is what these 6 attorneys that are now all of a sudden pro bono are going to have to, present to the court. Like that. But they're certainly not listening to people on the internet. These 6 attorneys did not go to law school to listen to some fake wannabe YouTube attorneys talking about shoulda, coulda, woulda. They will not be using any of you all this fake outrage. They will not be using any of your videos or your posts or anything to help them with an appeal. Unless you are citing a fact or a law, your opinion will not be used to help them build an appeal to the court. Your opinion is irrelevant. So we now have, let's see, what's his name? Is it Class E? Class E. Shout out to Class E. He did a video on yesterday regarding the young lady that was jumped by 3 Carmelo Anthony supporters, and she decided, her name is Sammy Lee, she decided to speak out. So I wanted to go over this and then, see what's the status update, because the 3 girls, 2 of them surrendered voluntarily to law enforcement. And of course, they have court dates coming up and all of this, and for what? Like it was just a brutal, savage attack for no reason, for someone that will not be able to pay their bills.
And she is the woman who was attacked by these 3 girls who were at a bar. They saw Sammy Lee walking out. She was white. They wanted to, in some way, tie this to Carmelo Anthony and so show their support. So these 3 women decided to attack Sammy Lee. And while they were attacking her, they said, "Free Carmelo." And they even, at some point, allegedly, again, this is alleged, said that they wanted to find the smallest white girl they could and beat her up. Obviously, this is not okay. Nobody's talking about this because it doesn't fit the narrative that a lot of people want to use in these types of cases, but we're talking about it here. So now that we have that part of the story, Sammy Lee, she was bloodied, she had staples in her head, and obviously she is traumatized from the situation. We're going to hear from the friend that was with Sammy, and her father is actually going to call into a radio station and say, "Listen, everything you guys heard is backed up by my daughter. She was there with Sammy at the moment that she was attacked." And then we'll actually get into an official statement from Sammy Lee herself and her attorney. Check this out.
I just wanted to let you know that the story about Sammy Lee is 100% accurate, because my daughter is the friend who was with Sammy that night. Sammy did get injured pretty bad, and
it's an understatement.
Scarred mentally for that.
Jason, is there any insight on why they targeted Sammy?
As you said earlier, and what my daughter has told us, is that they were looking for a small black girl.
So did your daughter hear them say
crazy.
"Free Carmelo"?
She 100% heard them say that.
All right, so that was Jason in Haltom City. If there's a racial hate
Shout out to
crime
Jason.
that's committed against my kids, no one's going to care. Media's not going to pick it up. Y'all will ignore it. Y'all will bury it.
Yep.
But then the slightest of offense from anybody in my tribe makes news. Do I have to play the story of the Stars Nazis again? They're like, "Oh my gosh, we can't stand racism so bad. We've got to punish these guys who did a racial gesture." Meanwhile, Free Carmelo beating the snot out of a little 5'3" girl, putting her in the hospital, had to get staples in her head. We don't care about that racism. We don't care when you get beat up. We don't care when you get oppressed. We don't care when the hatred and the violence is directed at you. We only care about it when it makes you look bad. Well, I think it's a pretty sick way to run your media outlets, people.
Yeah, and honestly, it's disgusting because I, for one, do care about people, just out of care for people. Don't have an agenda. Don't care if they look like me. They don't look like me. Someone has been wrong. If someone is being wrong, should speak about it, call it out, and have that conversation and make people aware of what's going on. In this case, so many of the people that were crying about the injustice to Carmelo Anthony, and I can name names, but I won't, that they don't care. Ask them if they know about this story, if they've heard about this story. They say, "No, I don't. What does that have to do with me?" And it's sad to see that people feel that way. And people,
it's like we're losing our humanity. What in the world does it profit a man to gain the whole world, lose his soul? What are people getting out of this so-called fealty to Carmelo Anthony? What are they getting out of it? These girls are going to go to jail and they're going to have a felony on their record. And I think that, what we do not see enough of in the court of public opinion, hopefully the court of law will make up for that. So even if they get a plea deal, they should still have some jail time. They want to sit here and set a precedent. I can guarantee you the prosecutors will ensure, as well as the judge, that they are made an example of. Because this should not be tolerable from anybody. It's savage. And all for someone whom, if you tried to call their parents right now and say, "I need $1,500 for my mortgage," they're going to be like, "We need $2,000 for our mortgage. So what's wrong with you? We're not sending you any money. You decided to go and attack someone using our son's name, and you want us to bail you out and pay your bills." They would care less that these girls are roaming the earth. They will not come out and thank these girls for jumping the smallest white girl they can find. And if they do, they deserve whatever fines, penalties, or lawsuits they have coming their way. No one would be happy about that. You talking about this girl having, I mean, the injury is so bad. The residuals of the injuries could last a long time. And she has every right to sue them. And maybe that's what needs to happen. So one way or the other, whether it be through the criminal case with their charges or through a civil proceeding, they need to face consequences. This is not okay to do. This is a horrible precedent. And then if anything happens where you have a white kid shoot or stab a black child and they get 35 years and everybody is demanding that they get life in prison, then it's going to empower the, people on the reverse end of this to do the same thing. You don't need stuff like this happening from I don't care people picking a side or not. I don't have to agree with someone else. I choose to follow facts, law, and evidence. But I'm not here to try to convince anyone that what they believe is, wrong or not based upon the finding of fact. I'm just going to give my opinion on it and keep going. It should never translate to someone has to be in fear of their life because they don't know if they're going to be randomly chosen to be attacked simply because somebody's mad at a verdict or ruling against someone they don't know, never met, and will not pay their bills, will not bail them out of jail. And now they're going to have to deal with having felonies on their records. And for what? He's still in prison. Attacking the smallest white girl you can find does not get Karmelo Anthony out of prison. As a matter of fact, they may have to join him in a jail cell. This is insane.
They just don't care about people, unfortunately. Well, Sammy Lee had something to say about this, and she spoke out through her attorney. Obviously, she's going through a lot of healing in this process, and she's not going to speak or do any interviews herself, but her attorney had something that he wanted to say to the people out there that are having conversations about this. And thank you to Amy for posting this official letter over on X. If you guys don't follow Amy on X, make sure you do that at @IamyLee on X. She says this is the official statement from Sammy Lee's attorney. What does he have to say? A statement of legal counsel for Mrs. Howery, Howery, Howery. Hopefully I said that right. Sammy Lee Howery. He says this: my client is a young woman who was violently assaulted and is recovering from serious physical injuries and real emotional trauma. Right now, her focus is on resting, healing, and taking things one day at a time. She respectfully asks that her privacy be honored while she does so. She and I want to be clear about several things. At its core, this case is about a violent criminal assault on one young woman. It is being thoroughly investigated by law enforcement, and while we are going to let that investigation run its course rather than draw conclusions before all the evidence has been granted and gathered. Investigators take time, and investigations take time. Rushing to attach labels, motives, or broader narratives before the facts are established serves no one. Well, I mean, if they said that, let's be honest, one of the main reasons we're talking about this Karmelo Anthony trials ended, and then after that, she said on her Facebook post, which is probably down, I can imagine at this point, that they said free Karmelo as they were beating her up. So yeah, I mean, if that's not true, then that's fine. We can move on without that being the main point. But if it is true, then I think that's important. He also says this: it only deepens division if we establish a narrative that's not necessarily true. He said it only deepens division and risks discouraging future victims from coming forward when they.
If people worried about whether or not she can prove they said free Karmelo, even if you remove that out the equation, what you're still left with is assault and battery. It doesn't change the fact that they attacked her. Honestly, what would be more of importance is expression of them saying that they're trying to just target the smallest white girl they can find. because then they're showing and proving they intentionally selected someone that was Caucasian and will probably have less of a chance to put up a fight. Now you'd be surprised how many small 5'2", 5'3" girls or boys out here that can actually lay hands and whoop some ass. But on average, you go out and it's 2 or 3 of you. It's 3 girls on one. And you talking about them catching her off guard out of nowhere. And just picking the smallest white girl ever because they're cowards. You know, even if she could defend herself or had the ability to do a couple tactical moves, you still outnumbered. And all of this, once again, for what? Because Karmelo is still sitting in prison. This is disgusting.
Most need help. My client does not see herself as a part of any movement, and she does not want her injuries turned into a symbol in someone else's fight. She was already victimized enough. Continuing efforts to use her assault to advance political, social, or online agendas only serve to victimize her again. I agree. When media coverage and social media commentary shift the focus away from what happened to her and toward the broader ideological battles, the victim becomes secondary to the narrative. It's true. That is unfair to her, and it sends exactly the wrong message to the other victims who may be already reluctant to report violent crimes. Ms. Howery has said it plainly. She condemns violence against anyone, regardless of race, and she does not support any effort to divide people along racial lines. She is a Christian, and she is leaning on her faith to carry her through this difficult time. She knows that East Texas community she calls home is a strong one, made up of good people who care about one another and who are not easily divided. We believe our local community is united in rejecting violence, rejecting hatred, and allowing justice to be carried out through the legal process. We're not going to allow one criminal act to define who we are or let outside agitators turn it into something it is not. Right. Like any victim of violent crime, what she wants most is to heal, to regain a sense of normalcy, and to see those responsible held accountable through the legal process. We ask that the public be patient with us, show restraint, respect her privacy, and a little grace while she recovers. And that is from J.D. McMullen, the attorney for Ms. Howery, Sammy Lee. All right. And then it says all media inquiries, interviews, requests, and requests for comment should be directed to his office. My client respectfully requests that members of the media not contact her directly while she continues to recover. Now, and speaking about the perpetrators in this case, there is more of a conversation that needs to be had here, because as we know, the woman who allegedly committed this violent crime, they turned themselves in. All right. So they showed up to the police department and they said, all right, let's just get this over with. What's our bond? They had a $20,000 bond. They actually paid that bond and they are out. So I want to go back through the story just to give you guys a refresher of what happened and maybe see some more information about what the police are saying in this case.
I think
because as we heard from the spokesperson from the local department, the local police department there, Mr. Brown, he said the FBI has been contacted and they may be involved. So 3 women now face assault charges in connection with a reported assault outside a Longview nightclub that went viral after.
Yeah, because they're being charged with assault still. And that doesn't go away because you got these idiots talking about what proof she had. They were saying free Karmelo. No, they targeted, the smallest white girl. That would be more sufficient in if you're talking about a hate crime here. Not free Karmelo, that's just a slogan. But if you remove that out the equation, they're still going to be charged with assault. So they're still going to jail. They still have their day in court. Let me put it like that. They still have to have their day in court. And there will be sufficient evidence to prove that they did this. 2 of them surrendered voluntarily. I can guarantee you at some point it's going to dawn on them, this shit is not worth any of this. Bet money that judge is going to try to make an example of them. Because this can't go on forever.
The alleged victim said attackers shouted, "Free Karmelo." Gregg County Jail records list Dejae Brown, she's 26, of Pittsburgh. So they weren't even from that area?
Nope.
Alana Murphy, 25, is from Longview. on warrants for assault causing bodily injury. Records show each received a $20,000 bond. Gregg County Jail records list Sierra Ann, I know I'm saying that wrong, Sierra Ann Fuller, 21. She's from Longview on the charge of assault causing bodily injury, $20,000 bond. We know all three of them are out. Longview Police Department spokesperson Ladarian Brown, he said that Brown and Murphy voluntarily turned themselves in on charges related to an assault.
Yeah, so two of them turned themselves in voluntarily. The other one was charged and arrested. I don't know if they picked her up from somewhere, but the other two turned themselves in voluntarily.
Assault reported Sunday outside the nightclub on the 300 block of Texas 63 Spur in Longview, excuse me. The arrest did bring in the total number of women charged in the connection with the reported assault to 3. So, as previously reported, the Dallas Express says that a woman publicly identified on social media as Sammy Lee alleged that several women attacked her after leaving Whiskey J's in Longview during the overnight hours of June 20th to June 21st. I would say nothing good happens after 11 o'clock. Nothing good really happens after 10 o'clock, but here we are. Lee alleged in her public post that the woman shouted "Free Karmelo" and said they planned to target the smallest white girl they could find. In a Facebook comment reviewed by the Dallas Express, Lee named Brown, Fuller, and Murphy as the women she claimed were responsible. Dallas Express did not publish the names in the first report because the police and court records had not yet confirmed their alleged involvement. Jail records now show those 3 women face charges in connection with the reported assault. Police warned against retaliation. Now, this is an interesting point. As previously reported by Dallas Express, Longview Police Department spokesperson Ladarian Brown confirmed Fuller's arrest during a Wednesday press conference and said police were aware of the social media conversation about retaliation, division, and possible attacks in the community. He said this: "We are also aware of social media conversations concerning retaliation, division, and attacks between members of the community. Those statements are being reviewed seriously at this time. We do not have verified information to support any broader threat to the public." Somebody saying, "Oh, we're going to do it again." Yeah, let me get in on this. It's sad, man. I've seen worse things than this. We talked about some of the things that were happening after the Karmelo Anthony trial with people reenacting what happened to Austin Metcalf and being stabbed. It's disgusting out here, to say the least. The Longview Police Department is actively investigating this matter, and we are in communication with the Federal Bureau of Investigation. Any credible threat, any attempt to organize violence, and any effort to intimidate members of the community will be taken seriously and investigated properly. Brown also warned residents not to let social media drive retaliation. We do not, as a community...
You know, what's so crazy? The FBI is coming in because, you know, the severity of this could escalate those charges up to hate crime and terroristic acts, especially if they are out targeting and intentionally imposing fear and terror into random citizens because of the color of their skin. Oh, and because they're mad about Karmelo Anthony going to prison for murder. Meanwhile, if they get indicted by a grand jury for charges filed by the FBI, they're definitely going to wish they never did any of that. This is madness. No one should be putting their liberty and freedom on the line for this. Ugh.
Answer one wrong with another wrong, Brown said. We do not let anger become retaliation, and we do not let social media become the judge and the jury.
Okay.
Now, the Free Karmelo claims is going to be important, and it's going to play out, and it's going to be a part of this, quote, narrative moving forward as this case goes forward. Also, Lee's original post connected the alleged Longview assault to Karmelo Anthony only through the phrase she said the attackers yelled. At a Collin County jury convicted Karmelo Anthony, 19, of murder on June 9th and sentenced him to 35 years in prison for fatally stabbing 17-year-old Austin Metcalf at a Frisco track meet in April 2025, as previously reported. Public jail records confirm the assault charges against Brown, Fuller, and Murphy, but they do not establish whether the investigation has confirmed Lee's alleged allegation about Free Karmelo and what they said, and any motive connected to the reported assault. Let me know what you guys think about this in the comments in the chat. I'm sure we're going to have more updates on this very shortly as we now move forward to going through whether they're going to be charged, how they're going to be charged, and what Sammy Lee is going to do when it comes to having to potentially face them in court. Let me know what y'all.
More than likely, she's going to sue them. Seems like they're gearing up for a lawsuit as well, because they want to make sure that this nonsense does not go unpunished. And I'm telling you, our judge gonna make an example of them. So for the appellate process itself, it's just some overview information regarding appealing a murder conviction. And as the attorney Dennis Spurling stated, you have a lot of complex legal processes in place and a lot of legal hurdles that these attorneys are going to have to overcome to even present a viable appeal that could successfully lead to overturning a murder conviction. So, filing of the appeal itself, you have usually between 14 to 30 days after the verdict. There's a review of the trial records. So, that would be the court transcript, which includes all evidence, testimonies, jury instructions. This review focuses on identifying any legal errors that may have affected the trial's outcome. Grounds for appeal. Common grounds would be the insufficient evidence, legal errors, ineffective assistance of counsel. Mind you, Karmelo Anthony's parents paid $75,000 when they could have utilized more of those legal defense funds to get attorneys they felt will be better. Personally, I don't think it would have mattered. But the fact that they had more money they raised, to fund the legal defense speaks volumes when they only put $75,000 towards the attorney, and yet they raised over $634,000. Then you have the appellate court decision. The appellate judges will decide, because it's typically 3 to 5 on the panel, whether to uphold the conviction, reverse it, or order a new trial. If the appeal is granted, the case may be sent back to the lower court for further proceedings. Of course, potential outcomes would be that the conviction is upheld. So the original verdict from the lower court remains in place. That's it. The conviction is reversed, meaning the defendant is acquitted or the charges are dropped, or there's an order of a new trial, meaning the case goes back to the lower court due to those errors. And the purpose of the new trial is to ensure that those errors are removed from the equation. It's like an opportunity to correct the errors, not necessarily present a whole new case like this just happened last week. No. It's the same evidence. It's the same, except any errors that occurred. Having an experienced criminal appeals attorney is crucial. He has 6 of them. In summary, appealing a murder conviction is a critical step for defendants seeking to challenge their convictions. And of course, it's important to understand this. So that's just a bit of information summarized. If you guys want the sources here, you guys can see A&E is being cited, aetv.com. Of course, the defense firm. So you have a few legal articles in here. Justia, a reputable website to get, breakdown of the law and actual statute penal codes for all states. So you can easily look up a actual statute or a penal code for any law that you need to, read up. And Justia has a great way of kind of putting everything kind of plain and simple. And if you guys need to fact check me, go ahead. But this is what it is, and it stands for right now. And I just wanted to go over that information, and would definitely love to get in contact with attorney Dennis Spurling, have him over in the LLC so that, some questions can be answered. I love his candid approach. I personally have a question about his views on the difference in a black versus white attorney, and if that would even change anything regarding the case at all. Because if Karmelo Anthony did not want to take the stand, having a black or white attorney is still irrelevant. My question would be, would a black attorney decide to put him on the stand? What if they didn't? Then what? So Mel says they bought Walmart when they could have had Zales. They went cheap. Raised all that money only to use 75,000. So thank y'all so much for tuning in. Hit that like button. All the little cult members are mad as hell. They're bigly mad. But either way, we're gonna go over the appeal once it's filed. It will probably be something I have to pay for, but whatever. So that we can understand what's going on. And hopefully you guys can, if you are able to tune in tomorrow. We will have Ryan Worrell on the show. Thank you all so much for your support. Hit the like button, share the content. Gotta run. And until the next one, Lady Luck Club out. Deuces.